pleasure to invite you to today's event at the Lagos Leather Fair. We have a top tier lawyer with us today, um, one of the very best in the profession, a top tier firm, head of sectors, an advisor to both corporate organizations and government. We have Chinyere Okorocha with us today, and I can assure you, you cannot have it better. So we are good to go. Before we go into the presentation today, which is, I guess, for most of us, something that is a matter of great concern if you are a creative, I would like to say that it's my privilege and pleasure to be the one moderating this event. My name is Tade Padeola. I am a lawyer, but more than that, I'm a creative. So I guess today you are having this panel that is, very, very in tune with what the issues are. Um, I would not waste your time. I would hand you over to Chinyere Okorocha right away because we've created a segment for questions from you. Chinyere.
Thank you so much, Tade. I'm so delighted to be here. I trust everybody can hear me. And how is everybody doing? How are you, Tade? You're muted.
Fine. Thank you.
Wonderful, wonderful. Very trying times, this COVID-19 pandemic. However, we just continue to trust the Lord to keep us all safe. So I'm so delighted to be here. Good afternoon once again, everybody. I hope we're keeping safe. I hope we are all, keeping to all the safety measures that the government has put out there. I'm also so delighted to be here, and I'm so happy that the Lagos Leather Fair decided to go digital and that we didn't let the current pandemic deter us from carrying out this very, very ever so important message. Indeed, the truth of the matter is the audience is even wider now that we have gone digital. And this is a message that needs to go far and wide, especially for our Nigerian local market. So the topic that we're going to be delving into today is titled The Creativity and Intellectual Property, the Copycatting Syndrome. And it's particularly important and relevant for producers of leather products to be aware of the kind of protection they can get for their creations, as well as the challenges from a legal perspective in terms of people copying or counterfeiting their products, and also what type of remedies are available to them or to you when this happens. And so just to give you an idea, if you could put up the slide, just to give you an idea of what we'll be discussing today, I'm going to give a general overview of what intellectual property actually is, because I need you to understand it. I've been an intellectual property lawyer for 29 years, and I just love that area of the law because I find it so interesting and so exciting. I'm sure if I wasn't a lawyer, I'd probably be producing something, be manufacturing something or inventing something. And I guess there's still time for me to do that. And so, so we'll look at generally what intellectual property is, and then we'll look at the types of intellectual property, because it's very important to understand that intellectual property comes in different forms. I oftentimes hear people say, trademark it or go and patent it, or have you copyrighted it? All these are types of intellectual property that we're going to look at today and try and identify what are the different ones. And then we'll hone down on the particular types of protection that you as a creative in the leather industry should be looking at. We're also going to, next slide, please. I go along. I'm on slide, the overview. You know, there's so many, apart from just registering or protecting your intellectual property, there are ways you can commercialize it over and above just selling it, you know, just manufacturing it or selling it. And then we're going to look at intellectual property theft. We're going to look at, you know, the challenges of copycatting and remedies. You know, so I'm going to start by telling you a little story, and that story is just to tell you that IP is all around us. Intellectual property is defined as creations of the mind, things that you use your human intellect to create or invent. So it can be a name, it can be a design, it can be a business idea, it can be a solution to a problem that has been found in the world, for instance, the Ebola or the COVID-19, you know, the cure. All these are things that we know, please go back, are things that we use our minds to try and develop. And so I put it to you that intellectual property, even though you don't know and you haven't taken cognizance of this fact, it is all around you. And from the minute you wake up in the morning and step out of your bed, and from that time to when you get to work, you will encounter at least 20 different types of intellectual property, from waking up in the morning to getting to work. And so let's do that experiment. So you wake up in the morning, if you're like me, I'm still on the slide that says intellectual property, thank you. You wake up in the morning, and if you're like me, you probably take a bathroom break. And when you've taken your bathroom break, I hope you will wash your hands. And you will wash your hands with some soap, liquid soap. And that liquid soap has a name. And the name of that liquid soap can be anything, but the name on the liquid soap is a trademark. Now, the liquid soap itself, the composition, the chemical formulation inside that liquid is also a type of intellectual property, and that is called a patent. Then you go back to your bed, you haven't woken up yet, you decide to just glance at your phone. For those that have social media accounts, you want to look at the social media, what's going on there, all the news on your phone. You pick up your phone. It might be a Nokia phone, it might be erstwhile BlackBerry, it could be a Samsung, or it could be an iPhone. All these are intellectual property. And even if you open the phone and look at the various apps inside the phone, like WhatsApp, like Skype, like Zoom, all those are types of intellectual property. And then the engine making the phone to work is also intellectual property. The design of the phone, whether it is square, whether it is round, whether it is a rectangle, or you know, the fine lines around it, is a design. Okay, so if you're not convinced, you decide to switch on your television and listen to the news. You might be looking at Channels Television, or CNN, or Sky, or Arise TV. All those are written in distinct ways, isn't it? Those are trademarks. Then the fact that you can broadcast the news far and wide is a type of intellectual property called copyright. If you decide to do your morning devotion and put on your cassette and be listening to the music from the phone or from a radio or from another device, the sound and the music is also copyrightable. You understand? So you haven't even left your house. I'm sure I'm at 10 by now. Then even if you decide to start getting ready for work and you put on your clothes, have a label, either Jola Sego outfit, you understand, or you know, some other name brand, or you decide to wear your shoes or carry a handbag, your Femi handbag, all those are intellectual property that you haven't left your house. So IP is all around us. People go out of their way to create these types of innovative things that make the world go round. And that's why it's recognized worldwide that over and above just creating the intellectual property, you should be able to benefit from it, have a commercial value. Even if you chose to get into your car, I mean, even the cereal you drink in the morning before you leave the house is branded. Then you enter your car, maybe it's a Honda or a Toyota or a Hyundai, they're branded. Then even as you're going to work along the street, you see the Sky Bank or the GTB, you understand, or you see Green Spring School or Lagos Business School, all these are trademarks or different business. You see Femi Handbags, outlets, it's a trademark. You understand? So IP is all around us, and that's why I find it particularly interesting. Am I frozen, or is my picture okay? Tade, because on my device, the picture is frozen. Or is it okay? You're muted.
The picture is frozen, but the audio is perfect.
Okay, I'm just going to sign on with that. That's one of the problems I usually have with that device, and that's why I sometimes like to do my Zoom on my phone. So I'll just quickly sign in again with the other device so that you can be seeing me. Right. I'm not just speaking. Right. Yes.
Okay. So I think while you do that, I would do a basic recap on the thought experiment that you are conducting with us.
Wonderful. Please go ahead.
Yeah, so I find your approach very interesting. This thought experiment that Chinyere is making us to conduct in our different spheres of life. I would say we do more than 20. I would say we do like 30 on the average every day. The way in which you have enumerated these, and that to me is a challenge on its own, because all the things we do that we take for granted are actually creations of the mind of someone who's taken time to make sure that these things are recognizable and distinct from the mass, from the generic. So I think, okay, now I can see your motion, so I'll hand the game back to you. Thanks. You're muted. You're
okay.
Muted.
Yes, I'm back now. Absolutely, Tade, absolutely, everyday life. I think that's the simplest way to explain what intellectual property is, before we now go into, maybe the legal ways in which they are defined. So if I'm to go ahead with the presentation, if that's okay. Okay, now you are muted.
Please go ahead.
Yes.
I'm in the flow. I'm in the groove.
Awesome. So intellectual property is all around us, and I find it so amazing. And that's what drew it to me as a young lawyer. And so we're going to look at the types. I've mentioned quite a few as I was telling my little story. And we're going to look at the types of intellectual property so that when you finish this masterclass, you become a guru and you'll be using the right terminology at the right time. So let's go on. So, okay, maybe to give you the World Intellectual Property definition of what intellectual property is. They say intellectual property basically refers to creations of the mind, inventions, literary and artistic works, symbols, names, and images used in commerce, and the protection provided for such creations under the law. So, I mean, I think my explanation is better than theirs, actually, if I were to say. Yes. So types of intellectual property. And I think that is slide 1, 2, 3, 4. Tech team, if you could flow with me, I'll be so happy. Types of intellectual property. So the 4 main types that we're going to be looking at today are the trademarks, the patents and the industrial designs, and then copyright. Now, actually, intellectual property is broken down into 2 main headings. One heading is the ones referred to as industrial property, which are the trademarks, the patents and designs. And then on the other hand, you have copyright, which are the artistic works. You understand? So if the tech team could please take us to the slide that says trademarks, that would be fantastic. But I will go ahead because I've got another copy of the presentation here with me. So like I explained in my little story, trademarks are the names or the designs or the logos that we put on the goods and services that we offer to the public for sale. They can be distinctive marks, graphics, logos, symbols. They can be words, or they can be a combination of all these. They can be signatures. They can just be lines, asymmetrical lines. Anything you can use as a source identifier. Because what the trademark really does is that it identifies the origin of the product. Tech team, you're not moving along with me. If we could move the slides along so that our viewers can flow with me, I'll be really happy. So I have examples of trademarks, because there are actually different types of trademarks, like we have mentioned. So a trademark can be a word mark. For example, which one will I use as an example? Apple, thank you. Apple is a trademark. That's just the name. It could be the name of a person. For example, Femi handbags. That's a trademark. It could be GTB, that's letters. That's a trademark. And then I guess this slide shows us quite a few trademarks. The Chanel, Dior, Fendi, Versace, Louis Vuitton. If you could go back to the slide just before this one so that our viewers can see the types of trademarks. So it says word mark, device mark, a word and device mark. And then there's something called service marks. Now we're we all know about tangible things we can touch. However, when a product or a service is intangible, we call it a service. So like a school provides a service, or a consulting firm like Arthur Andersen, for example, or a school like a Lagos Business School, or a bank like UBA. All these provide services. So they are selling something to the public really, but that thing they're selling is not a tangible thing. It's actually intangible. So it's a service mark. And these are also protectable as trademarks. And then sometimes you have signatures. So you have the Guinness, is actually a signature of a person. You have the Louis Vuitton is a signature, I believe. There's one that is on this one. That's Arthur Guinness, is a signature mark. I know that Audio Menome, I hope I'm pronouncing it well, a Nigerian fashion designer. Her trademark is a signature. There's Salvatore Ferragamo. There's signatures of the people. So that's it for trademarks. And then we go on to patents. That's another type of intellectual property. So patents really protect inventions. Patents protect inventions. So it's really the legal protection you get for an innovative idea that is new. So the truth of the matter is a patent must be novel. The requirement for novelty is so high. And that means that for you to get that protection, that idea must not have existed in what they call the prior art. And the prior art means all the knowledge in the world, nobody else has done something like that before. Then you can be allowed to get a patent for it. Now, patent is very unique in the sense that it covers a wide range of things. So even the pharmaceutical products are patents, can be patented, like the cure for this coronavirus now is going to be patented by Pfizer. We heard there's there's a vaccine, you know, all those from the GSK and all that, all of them have their own, will eventually have their own vaccines. But patents can also be mechanical. So like the engine inside a Toyota car is different from the engine inside, say, a Hyundai or a Honda. Those are patents, you know, or the engine or the mechanical way in which a phone works, or an air conditioning, you know, or even the drinks that we have or consume. You can see they all have different distinct tastes. So they came about by a mixture of different formulas, and each one is patentable. Obviously, intellectual property aims to exclude other people from using it if you are the originator, such that you can have a financial benefit to that intellectual property. But they're not rights in perpetuity. So for example, trademarks last for, I think, 7 years in the first instance, and then you can renew it every 14 years. But for the patent, you can only own a patent for 20 years. After that, it enters the public domain and anybody can have. That's why you sometimes see so many of the same type of invention. That's because the patent has run its course, and the owner of the original idea, we're hoping, has regained the cost that they used to manufacture or to invent, I guess, to work the patent. Another important thing about patents is that they must be able to be industrialized, you know, replicated on an industrial scale. So those are just some examples of the patent. And then we move on to the industrial designs. I'm sure you guys will be very interested to know about the designs. That's one of the ones that is very relevant to the leather industry. So industrial designs protect the aesthetic or ornamental value of an item, you know, so how you arranged it, if it's a handbag, you know, or the shoe, or the phone, like we've mentioned, or even the Coke bottle, the shape of the Coke bottle, which they say is the silhouette of a woman, actually. If you've never thought about it, it's supposed to be the silhouette of a woman. The light fittings in our houses, the shapes they have, bottles, you know, for putting things, the shape of a computer, a television, a car, a motorcycle, all these are 2 or 3 dimensional shapes that can be protected as a type of intellectual property. And the interesting thing is that if you don't believe it, before they come out with the actual design of that item, they will have so many prototypes. They will have so many different designs or drawings that they will go through. Somebody is doing that creative process to see which one looks aesthetically more beautiful, which one doesn't appeal to the eye, which one will appeal to younger people, and which one will appeal to the market, you know. So all those are taken into consideration. And then we quickly move on to because I know you're going to have a lot of questions, and we're going to move on to copyright. And that's the one that most people know because of our artists. You understand? Everybody knows about the music industry or the film industry, Nollywood. The protection you have in your music or in your broadcast rights or in your literary works, you know, if you move to the next slide, you'll see it. Is actually what is copyrightable. And so those are literary works, which are your novels, you know, even the labels that you put on maybe medicines, that subject of copyright. I wrote out some more examples here that we might find more interesting. Then the computer programs that are written are copyrightable. And then you have your musical works, so we have music, sound, and all that. Your songs are all copyrightable. Artistic works, so your paintings and architectural works, those are all examples of artistic works. And sculpture too is copyrightable. Again, we're talking about intangible rights. And then your cinematograph films are the movies, really. And then you have sound recordings, that's the broadcast, the TV broadcast and all that. And then Yes, it's there. You know, but the important thing about copyright is that it must be in a fixed medium. That means if it's an idea on your head, it's not copyright. You must put it in a fixed medium. So either you have an idea of a book in your head, then you write it down, or you have a play script in your head and you write the script of the play, or you act it out as a movie, or you have this beat in your head, you know, and you don't even write down you have to write it down in a fixed medium, or a painting in your head is not copyrightable. It has to be on the canvas, and the computer program has to be written and all that. So it has to be in a fixed medium. Now for copyright, for all intellectual property rights, really, the primary thing is that it excludes other people from using it without your permission. It's an exclusionary right. However, there are exceptions to when someone else can use the ownership rights that you have. And so I had a slide there that talked about the exceptions to when you can copy somebody's copyright, you know. So for example, fair dealing, that's purposes of if you're doing research in the university, you know, or you want to do educational purposes, you're teaching something, or you want to do a review of a work, or you want to even say it in the news, you know, you're reporting current events and you use the material to report it, you know, those are just some exceptions that I thought to throw in there. Now, for intellectual property, it's very important that you recognize that you have two main types of rights when you create an intellectual property. And I say intellectual property, you know, because sometimes we find it difficult to understand intangible things because it's not something you can hold on to. But I just want you to turn your mind and kind of consider it like it was physical property that you are holding in your hand. Physical property like your bag or your shoe or your phone or your house or your car. Just as you would want to protect those physical property that you have, so it is with intellectual property. It is your property, you own it, and therefore you must take steps to protect it, to ensure that other people do not either misuse it or claim to own it or copy it. Because when you create that intellectual property, particularly the trademarks, for example, you acquire what we call goodwill in the marketplace, because the people who buy or patronize your brand obviously do so because there's something positive they get from using your brand. And that brand over time develops a goodwill. So you amass customers who love you, who love your products, and who always are returning to purchase your product, and they keep you in business. But if you allow someone else to use it without permission, then it erodes that goodwill. And then the benefit that should come to you from owning that intellectual property, you know, is decreased or totally disappears. You know, and we're going to look at the reasons why the copycatting and counterfeiting is so dangerous or difficult, even socially and economically, and also has a personal negative effect on people. You know, so two rights that you may have are the moral rights. Okay, and I just wanted to mention in terms of copyright that unlike the other types of intellectual property, which, you know, sometimes to have the backing of the law, you have to actually go a step ahead and register it. Copyright doesn't need to be registered for you to own the copyright in the work. So it's not a requirement that you have to register it to have that right. Although the Nigerian Copyright Commission has what we call a deposit system, where if you create an artistic work or whatever it is, you can go and deposit that work with them in order to ensure that it's very clear that you own it. That's all it does. It indicates that you're the owner, so that in case there's a dispute in the future, you can actually show that I deposited this work 10 years ago. How can you come out today to say that you own the copyright in the work. I also want to mention that for the trademarks, you also must not register, because you do have some rights in an unregistered trademark. However, your rights become much stronger and easier to prove if you actually go the step further to register the trademark. For the patents must be registered, you know, for you to acquire the patents under the law, as with the designs, although there is something to do with unregistered designs, just to put that out there. So the moral rights are the rights that you have to say, I am the owner, I am the originator, I am the creator of this right, and I demand to be recognized as the owner. And then the second right is the economic right that you have in that intellectual property. And that actually refers to the financial benefit that should come to you by virtue of the intellectual property asset that you have created. I like to call IP assets because they are assets that can be monetized. And so how do you monetize your intellectual property rights? So over and above manufacturing a product and selling. Before we go into this, Tade, did you want to ask me any question as we go along? Did anything strike you as I was going along? You know.
Can you hear me?
Yes, I can.
Okay, so I might be getting a little bit ahead of the audience. You are a lawyer, you know what I'm talking about. There's something called passing off.
Yes.
And the aim of those who do it is to make what they do look like what you have done and get the benefits. And I understand that they get the benefits without going through the pain of the creator who must have taken time to develop the prototypes, who must have spent money to pay workers who for materials. And now this passing off, which is an aspect of copycatting,
yes,
is a very deliberate thing. It's not something that happens by chance. If I make a bag and I call it Versace, or I make something, a fashion item, an accessory, and I put the name of a famous designer to it, I must intend to actually gain benefits. But as you were taking us through this process, I realized that it actually is a moral issue. And not many people understand this moral dimension to the creation. I would like you to, take us through this aspect, because everything at the end of the day is a matter of the community you create. And you have explained to us that going through the process of creation, getting a client base, it's all community creation. So when you have like something that takes away or detracts from all that effort, then not just the law, but morality is called into question. But I am interested.
Absolutely. In passing off. Okay,
yes.
So when you have passing off is actually a common law principle. And why is it called common law? Obviously, as a lawyer, you know that Nigerian laws are based on the UK common law. So because Nigeria was colonized many years ago, most of our legal system is based, our foundation is out of the English common law. And so passing off is a common law principle that deals with people who may want to misrepresent their own products as your own. Now, we distinguish passing off from the other aspects, which is infringement. So, for example, if you've created a work and given it a certain name, and someone makes a counterfeit or a copy of that product, there are various things in the product that can be protected under intellectual property, like we've learned today. There's the name of the product. So it might be the name that they have copied, or it can be the design on the product that they have copied. But what registration of a trademark, for example, does for you is that you don't have to prove anything else but the fact that they have copied your product or name, product name. So you don't need to bring evidence of sales. You don't need to show that there was an actual infringement or negative impact on yourself. You don't need to show the goodwill in your product. That's called infringement. And you go to the courts and you file the necessary papers. Now, the opposite of infringement is passing off. And passing off is usually used when you haven't registered your intellectual property rights. So they're still saying that you own that moral right to the product or the thing you've invented, irrespective of the fact that you didn't register it. And so you can fall on the common law principle of passing off their goods as if they were yours. However, the problem with passing off is that the whatever onus is on you to show that, one, your product was copied, two, that you suffered a negative impact from it, maybe sales or something and all that. Three, the three main elements of passing off that are more difficult to prove than if you had gone ahead and just registered your trademark. So that's why we always advise you to protect. Even though passing off, it can be done and it is used, however, it's a bit more difficult or stringent on the part of the owner to protect it. And maybe by the time I get towards the end of the presentation, further down, you will see where we dealt with all these.
Thank you very much. Please go ahead.
Okay, so I'm going to quickly go over these because as fast as I can in how to commercialize your IP rights. So there's something called licensing. So sometimes, you may not, you're making your own product, you're selling it. However, your sales are not that fantastic. And you want to expand your reach. You might give a license, what we call a license, to someone else to actually use your trademark. It might be in another jurisdiction. For example, a lot of the products we find in the market today are brought into the country, and we have agents who have licenses for maybe international manufacturers to sell their products. This happens a lot in the pharmaceutical industry. So that's basically what a license is. Then you move on to a franchise, and we know franchising very well because there are a lot of franchises that exist in Nigeria. For example, KFC is a franchise. I guess McDonald's, they're not here yet. Domino's Pizza that you see here is a franchise, and so on and so forth. Franchise basically is you use the business model, you're authorized by the owner to use the business model they are using to sell in a certain jurisdiction. Franchising usually happens when you want to expand beyond the shores of your headquarters, for example, but you don't want to put down the money it will take you to open up that business, the capital outlay. So you give a franchise is actually a license. However, it includes the business model. So you will be exchanging the entire business ideas, the get-up of the company, the use of the logo, the way the internal shop is structured and all that, the recipe of the chicken, all that will pass over to the franchisee. Then you have a joint venture. You may have expertise in drawing the design of a shoe. However, someone else is really good with actually manufacturing the shoe, putting it all together. Then another person is actually really good, has money, is loaded. So the three of you go into a joint venture. Each person brings a different aspect of that business, and you form an alliance and you all make money. And it's cheaper for you at the end of the day. And sometimes you may have used the product, I'm on assignments. You may have used the product for a long time and it's no longer of use to you, and you decide to assign it to someone else. Maybe the direction of the company has changed. You used to manufacture shoes, bags, and belts, but you decide that you know what, I'm no longer going to be making belts. It's not worth my while. My clientele are not in that direction. You assign it to someone else to use. You understand? So once you assign, it's similar to a sale. You no longer have that intellectual property. And then merchandising, obviously putting your brand on other people's platforms. They use it a lot in sports, you know, where you have sports goods. So a company that makes toys originally will put the products of maybe a film. Which film will I use? Maybe Barbie. We'll create Barbie dolls, or even in the fashion industry, merchandising is very, very, very active, because you can put your brand name on various items, cups, on the footballs that are being sold, on the clothes, you know, so it involves using a name or symbol, distinctive style, which has acquired a certain brand recognition, and you use it to promote your own product. Okay, so let's move into intellectual property theft. You know, so I just need you, I would love the slide before this, I would love us to be very aware of the fact that we should try and monetize our intellectual property. And it doesn't only come from selling your own product. Enter into alliances, look at the issue of merchandising, look at who you can enter a joint venture with. There's so many ways. Collaboration is the name of the game right now. Look for who you can use to leverage. People will like ideas like your own, you know, and come together, and, you know, the capital outlay that you need might be less, and that just might be what you need in order to move forward. You know, like, so how I stated earlier, we have both moral and economic rights in trademarks, and these are held exclusively by the owner or creator of that intellectual property. However, the problem arises when people copy either the name of your product or they copy the design that you have. And so that's basically what copycatting, or what I like to call counterfeiting, is all about. And it's very, very rampant in the leather industry. So I tried to do some definitions. And the definition of a copycat is basically someone who acts or imitates somebody else. Someone who copies another person's, either their behavior, their dressing, or their ideas. So you become an impersonator, an imitator, or you mimic something. You dishonestly create a product that you weren't the originator of it. This is taken very seriously internationally, you know, and we're going to look at some statistics too to see how indeed the fashion industry, which is where we are right now, has such a huge case of counterfeiting, such that it's even a criminal offense, and sometimes you can trace it back to criminal syndicates like the mafia, for example, you know, because the amount of money involved. They say the fashion industry alone is worth over $600 billion US, you know, so a lot is at stake. So just to put it in context, with respect to the leather industry, intellectual property theft can occur in the following ways: selling a product with the trademark identical or similar to an existing trademark of another leather maker, or imitating the industrial design of another leather maker or dressmaker, or copying the creative sketch. You know, those are ways in which infringements can occur. Now, I want to differentiate this moral right from the economic right. For example, if Femi Handbag sells a bag to me, they've sold the economic right, but they retain the moral right. I can resell that bag if I want to. You understand? So the economic right has passed from them to me. I can resell that product. But what I can't do is tamper with their moral right. And the moral right is that I cannot remove the I at the end of Fumi or Femi, sorry, Femi handbags. I can't remove the I and put, say, a C to do with Chinyere, my name. Or I can't remove an aspect. Maybe they have a green part of the bag, then I change it to another color. I can't do that. And those are sometimes the problems that we enter into. And sometimes it's just about educating people as to what they can and cannot do. It's very important that we get to know it. And I know that a lot of people on this call must have been victims of this before. So let's look at some statistics. So some research was done by the Organization for Economic Cooperation and Development in the European Union. And they found out that, and this was in 2009, it shows that leather products such as handbags and shoes are in the top 3 list of counterfeit products worldwide. You know, and we know that counterfeiting cuts across all industries. It can even be pharmaceuticals, it can be electrical goods, but it's interesting to note that leather products was in the top 3. So if you can really zoom in, you see footwear was the highest, Jesus. Then you have knitted and crocheted things. Then you have articles of leather. Very sad. That is over and above equipment, watches, medical things, cosmetics, toys, jewelry, pharma products. Leather is number 3. Very sad. So it just does need to be tackled. Some more data to show you how important it is. And I'm just using the international brands because that's where the data is. I'm a local Nigerian Igbo woman and I love my country, and where I can find the data for Nigerian statistics, I will readily do so. So please don't think that I'm using the Gucci and the Alexander Wang and so on and so forth because I'm so, favored the brands. No, it's because the statistics and the data is easily available. So Gucci Inc., Gucci America, one of the world leaders in leather products, was awarded $9 million in damages by a US district court in an anti-counterfeiting case. And I think we all know, or we may know, that the top 5 most counterfeited leather products in the world are Chanel, Louis Vuitton, Prada, Gucci, Fendi, and Dior, the most counterfeited in the world. Alexander Wang was awarded $90 million in damages in another anti-counterfeiting case, which involved trademark infringement and domain name encroachment. Maybe this might be a good time for me to mention domain names, even though it wasn't specifically in the presentation, but it is a type of intellectual property. A domain name is basically your internet address. And what we have found, sometimes the counterfeiters go ahead and register the domain names of well-recognized or well-known marks and put it out there. And then they try and use that information to try and sell the name back to the owner. It's just a scam. So you have to be very, very well aware that if you're building a brand, you have to look at your business address on the internet, which is really what a domain name is. The last statistic that I want to just bring to the fore is that Chanel, they make products too. They recently won a lawsuit against 24 Amazon sellers. Now, Amazon is the platform that you can use, a retail platform you use to buy and sell things. So people, ultimately, we're going to look at how the age of the internet has increased the opportunity for counterfeits to get around easily. So Chanel recently won a lawsuit against 24 Amazon sellers, with the court decreeing that the sellers cease and desist from trading in the counterfeit items and pay $100,000 to Chanel on each item sold, each. You know, so it's something that we must take very seriously. Now, like I said, due to the rise of e-commerce, you know, as the preferred way of making purchases, copycat products have been largely sold online. And this has led to fashion brands filing infringement actions, you know, all over the place on the platforms used, not just on the people who are doing the counterfeit or copycats, but the platforms used to sell them. Again, Gucci is an example of this. So they filed a suit against 30 different websites that were used to sell it. But let's move on. So what can be done? Because I know that's where we want to get to. What can be done? So we can either be proactive or we can be reactive. You know, and the problem in Nigeria is that sometimes, a lot of the time, we're always reactive. We react to, oh my God, someone has stolen my name or somebody has copied my design. You know, but what you were supposed to do in the beginning, to be proactive, you didn't do it. You know, so what can we do? So one of the main things is that even as a small business, it's very important. Of course, IP protection filings is top on my list because of the added benefit that it gives you, or protection it gives you to have the backing of the law if your product is copied or infringed upon. You know, but over and above that, every organization, whether you're big or small, you know, or, you know, medium size, you must have a plan for anti-counterfeiting. So you have to prepare a plan beforehand that I'm making this product, my business is growing. If I find any counterfeit, this is the standard operating procedure that my organization will take. And this is a plan you set into motion now before as a proactive step before it happens. You know, what that does for you, actually, and I'm sure that maybe others today, throughout our wonderful 4 days, because I joined some of the sessions, have spoken about business structure, actually putting your businesses in some sort of structure and governance structure, you know, having your contracts with your employees and all that. I believe someone must have spoken about that. And so what I'm saying is you must have a plan. And that plan has to include registration of your IP as well as enforcement mechanisms you're going to use. And when I talk about registration, I don't just mean registering. I also mean you identify what is the IP you want to address, to register. So you go through that list of 4 that we've explained today and choose the protection that you need, you know, works for the situation, for the work you created. Then you have to look at the territory where you register it, because intellectual property protection is usually territorial in nature. That means if you protect it in Nigeria, it doesn't cover London. Or if you protect it in Nigeria, it doesn't cover Ghana. Or if you protect in America, it doesn't cover London. Each country has its own intellectual property laws that you must be aware of. So you choose the territory. Where do you think I might expand to in the future? Or you also have to consider the fact that Nigeria has very porous borders. The borders between us and in fact, Nigeria supplies most of its goods. I think 60% of the goods found across West Africa are from here. You know, apart from the international one, that's different. But our borders are very interborder trade is so high. So if you're in Nigeria as your main market, you must consider our surrounding boundaries to also obtain protection in. You also need to know the kind of product you're selling and where are the counterfeit or copycat hubs. You always know where they are in a nation. So if you're going international, you must know where are the key countries that you must go to in order to ensure that nobody copies your brand and takes it there. You must also educate your customers. This is very important. Educate your customers and raise awareness about the possibility of there being counterfeits for your products. You must let them know that it is a potential problem, but you now point them to the direction of this is how you know that this is an original product. This is how to protect yourself from the harm that could come from buying a counterfeit product, and even reward your clients when they continue to patronize you. You must also create an avenue for your customers to be able to bring to your attention anything they may have found out there that is a counterfeit of your own product. Bring it to their attention. It's very, very important, but that avenue must be created in this plan that we've said you must create. Now, one of the things that I always suggest that people do is to have some distinguishing features on your own product. And those distinguishing or security measures, sometimes, usually in the makeup or cosmetic space, you see them, they put certain tags on the cosmetics, or there's a medicine, there's serial numbers that if you check the serial number and you can't find it, you know it's not an original, because sometimes the copies are so genuine, you won't be able to tell the difference between the original and the copy. So you have to invest in some anti-counterfeiting technology, or you put a distinctive thing on your own. For example, the Louis Vuitton shoes, the sole, sorry, not Louis Vuitton, Christian Louboutin, the soles of their shoes are red, for example. And anywhere you see that red heel, it's them. So what can you create around your own product that once you see it, you just know immediately, this is Chinyere's handbag or Chinyere's, whatever. And then always monitor. You have to find, if you can't do it, you outsource to people who can. Monitor the channels where you sell your products. Monitor that's online, because we've established today that a lot of the time online is the place where the counterfeit products or copy products are sold. But you must also monitor the physical markets. You must be able to go from time to time, go to the market and have a look at what is happening there to see whether or not your product has been tampered with. I believe that I did cover the slides in my explanation. Let's just make sure I didn't miss out anything. Okay, so proactive steps. Okay, so there's a part of it I haven't spoken about. So a restrictive agreement. So sometimes that copycat might be someone who is close to you. It might be someone who has worked in your company before, someone who knows all your trade secrets, a choice staff who has decided to set out on his own. And in setting out on his own, he carries your whole business business model and all your trade secrets with him. So what can you do to protect yourself? And it's very important that these things are put in place early. Get them to sign agreements that restrict them from being able to carry that knowledge with them. It's very, very important. And sometimes we fail to do these things. And, at the end of the day, it's a question of, had I known? Non-disclosure agreements. Every organization, no matter what industry you're in, whether you're manufacturing, whether you're in the service industry, you must be able to restrict someone from using your trade secrets. So it's sometimes in perpetuity, sometimes it can be for a 5-year period. It depends on what area, what industry you're in. There's also what we call non-compete agreements. That means they cannot go and set up the identical business to your own and now be competing with you in the same space. It's legal. And what these agreements do for you is that if should it happen, you have the backing of the law. Well, you sign this thing now. There's nothing, you don't need to prove anything. It makes your life easier. You don't need to start bringing evidence, I exploiting this J and so on. You just show the agreement that he signed and you're good to go. Okay. Yes, we've talked about unique markers on the products and okay, so infringement actions. Okay, so let's move into other remedies. So I like to say that if you have been beaten, or if you've fallen a victim of copycatting or counterfeit, there are two approaches you can take. One is the civil action, or one is the criminal. These are all both legal. So the criminal, the civil, let's start from the civil. That will be the administrative or regulatory format that is available to you. So that would be your maybe cease and desist letter, you get a lawyer, and oh, please, guys, I know they say lawyers are expensive, but lawyers are your friends. Tade, you agree with me, right?
Yes, I was coming to that. Yes.
Yes. Engage a lawyer to do this, you know. I mean, it's more expensive for you to try and protect yourself when the problem has happened than it is to pay a lawyer to draft all these things for you beforehand. But you get a lawyer to do a cease and desist letter. The letter basically just says, I own this trademark, or I own this intellectual property, or this design has been registered by me. Cease and desist from copying. And you give them a number of days within which, if they don't comply, you either threaten legal action, or you can make it omnibus and say, if you don't within 7 days comply, I will use the apparatus of the law to come against you. So that one, you haven't really said what you're going to do next, but it is a veiled threat. You can also go to say, a trademark registry to do what they call an opposition. If you see someone who is registering a trademark that is similar to yours, or you can file a petition to the police on that. Okay, that's criminal. Let's not say petition. To NAFDAC, for example. So NAFDAC is also an administrative remedy. You also have the customs. If you have an idea of a shipment of counterfeit products coming in, you can hand in hand with the customs authority try and bring it to their attention, and they can set up some sort of a mechanism to arrest the ship or the products that are planning to come in. Then on the other hand, you have the criminal process, and this is found under Merchandise Marks Act. I didn't want to be too legalese today. I just want to, you know, say it in a way that can be explained. So the criminal, the counterfeiting of products or forgery is actually a criminal offense in Nigeria, as it is internationally. And it really refers to the manufacture or the sale or even possessing machines that can be used for counterfeits, or the deceptive use of another person's product as if it's yours. All these are punishable under the law. So you can file a petition with the police, and you can actually get them to do what we call raids. So you raid the area of the place where you think the goods have been packed. And what those raids do is that they kind of cripple, if you're able to raid a siege and seize what you find, it cripples the business, you understand, of the counterfeiter. There'll be financial loss to them. It sensitizes the public as to the fact that, yes, there's an owner, somebody who actually owns this product, you know, so there's so much benefit in doing those raids, and they come in handy. And you can do the raids over and over again. You know, you hook onto one person and you follow it through such that they will look for a softer target. You know, at the end of the day, the loss they're getting from copying your product is not worth their time, and they move on to the next easy target. And our time is really fast spent. You know, so in conclusion, yes, I think I have done this. I mean, obviously there's the court action. Sorry, I forgot to mention going to court, but we have mentioned it here, infringement action or an action for passing off. You know, you can ask for an injunction, you can ask for bringing up for destruction of the products, you can get damages, you can recover your legal fees and damages to the loss you suffered by the person trading in the counterfeit products. All those are available to you. So what am I saying in conclusion before we quickly go into question and answer session? And I know Tade has a long list there. Concluding, the importance of setting up proper structures for your business cannot be overemphasized, whether or not you're a small, medium, or large business. It increases the value of your business and it makes you attractive for investors and other collaborations. So it's important that these structures are put in place. And one of those structures is protecting your intellectual property. is something you must address from the very beginning. And if perchance you've been in business already and you haven't done so, it's important that you do so. This protection of intellectual property is just one part of it. We've spoken today also about getting your employees to sign contracts of non-compete or non-disclosure. All these are part of the business structures that you must do to ensure that your intellectual property is protected. These things we've talked about today are particularly important in the fast evolving digital world, where new technologies and systems are becoming more and more relevant and rampant. Your intellectual property is a valuable asset that can be monetized. And by applying the various options we've discussed here today, it will be in your benefit to be able to take advantage of them. I think you must also take particular notice today of the remedies that we have discussed today if you've become a victim of intellectual property theft or copycatting, and avail yourself of the advice of trained professionals like myself and Tade here. So thank you, everybody. I hope that this is the end of the presentation, and I'm open to you for any questions that you may have. I think the last slide has some contact details if you need to reach out for further information, or you reach out to the organizers of this wonderful Lagos Leather Fair, and I'm sure they can get in touch with us if you need to. Thank you very much.
Thank you very much indeed. Even as a lawyer, I have learned a thing or two from your presentation today. Mainly because intellectual property is such a wide field that if you take your time, you listen, you may learn a thing or two. So the questions have been coming in. We have 4 questions already from attendees. And the way I like to go about it is to try and address some and leave Chinyere to address some of the questions. I don't know whether you've seen the questions. Good.
Okay.
I'll go with the first question.
Please go ahead.
Which battle have I? I have not gone to court on behalf of a client who is a designer yet, but something happened in this present year, which I think is instructive to all creatives. A manufacturer, a big manufacturer, poached the managing director of a rival manufacturer, who both of them are listed on the Nigerian Stock Exchange, and everybody was asking the question, how did this happen? And while Chinyere was addressing the subject, the answer came to me. The first employer did not do a non-compete agreement with the MD. So the rival simply poached and got more than his money's worth in a new employee. So this is a challenge for you setting up business in Leatherworks. Whenever you are taking on a skilled worker, you need to be conscious of this. It is not wickedness to enter into a non-compete agreement with a key staff, because whatever processes your employees learn can be replicated outside of your workplace, and you need to be careful about that. Chinyere, I'll hand over the second question to you, or any other question you would like to address.
I just wanted to add, yes, indeed, what you said makes a lot of sense. I wanted to also add that there's something that when you're in the employment of someone, the intellectual property that you may create while you're there, depending on your contract of employment, may actually belong to the business and not to yourself. I'll say that again. The intellectual property that you create while in the employment of a certain organization, in some instances, belongs to that organization, depending on the contract that you signed with the person. So you also have to be, I mean, speaking from the other side now, from maybe an employee, you understand, you have to be careful what you're signing. Now, if you contract a work or commission a work, the work continues to belong to the person who created the work. So what you need to do is to get that person to assign the right to you. And we've talked about assignment today. So it's very important that you're very conscious of these little nuances that you may not know about. Again, get a lawyer to explain it to you better. Now, one of the questions here said, how do you solve the issue of someone using your picture of your work on their banner or social media handles? Okay, that's happening a lot now. In fact, I'm on Instagram and I suddenly saw my picture on another, somebody created an Instagram account and put my picture there as the picture on the, so someone now came to me and said, madam, is this you? I said, no, yeah, it's my picture, but is this your handle? I said, it's not me. You know, so I think various platforms have a channel where you can actually bring complaints. So for example, you did mention social media. So I think by social media, you mean either Instagram, Facebook, Twitter, LinkedIn. All of them have a channel through which complaints can be brought. So just like you would a physical infringement or physical copy of yourself, you have to go through that channel to try and, one, either investigate who the person is, of course, write to the platform to remove the offending image, and you have to give evidence as to why you think the image is not, or the image of your product shouldn't be there. You understand? And you have to make your case. It's not just by merely saying it's my product. So those things we talked about earlier on, or how do you show that you, because for example, copyright, it's not, you don't have to register it, you know, so you have to maybe have deposited it, or you email it to yourself. These are ways you can prove ownership. You understand? If it's a trademark that they copied on your product, that is on your product, that one, just bring out your certificate and show them I am the owner. You don't need to talk anything else. But passing off, like we've said today, is a bit more difficult. So just as we do in the physical space, some of those rules will apply. I also know that some jurisdictions actually have social media laws that cover and protect all these things. I believe in Nigeria, we're trying to put together one last year. I'm not sure how far we did in terms of that, although with the recent problem that we had with the NSAS movement, remember there's some restriction on media thing going around, you know, but let's not go into that. You know, so that would be my advice. There was a question that dealt with shoes. It says, is it possible for a shoemaker to patent his designs, since most of us can create new designs? Now, remember, I don't think patent will be the relevant law or IP protection for shoes. It's probably not a patent. It will probably be a design. And so if I were to change your question and put the word design there, let me see. Is it possible for a shoemaker to register his designs as registered designs, since most of us can create new designs? Yes, it is possible for you to register the designs of your shoes with the Nigerian Trademark Patent and Design Office headquartered in Abuja. But you must show, you know, so there's certain things you must provide. You must show the physical drawing and specification of the product. It's not just enough that you show the physical shoe, because they're going to, you might have to submit the shoe itself, but you also have to have the drawings and things like that. To distinguish a bit for you, the patents are usually inventions that solve a problem that we have in the world. So, for example, medicines. For example, the engine. in a car, how to make the fuel consumption more. Yes, just 5 minutes to go. Yay, we're almost done. Yes, how to stop the emission of fuel into the atmosphere. Those are the ideas, the innovative ideas that solve problems, you know. So that would be, unless if there's some inventive step in the shoe design you have made that when the person wears it, their leg doesn't hurt, for example. So in that case, maybe the shoe, what's that thing you put inside the shoe? The foaming thing you put in the shoe that can be for people with arthritis, for example. That's an invention that can be patented. You know, so I'm hoping that I've answered the question.
You have indeed. I can't believe that we're almost at the end of the panel, because time flies.
Time does fly, honestly.
But I'll try and do a quick recap, touching on the key aspects that you mentioned. Chinyere did say that you have to be both proactive and not just reactive. You have to try to preempt what might happen. And in the light of that, I would like to say that I believe that the failure of our society to evolve working guilds, as we used to have in the past, and if you go to Europe and the US, you will still see that the guilds are still working, is a way to ensure that copycatting and counterfeiting is reduced. There will always be the temptation, because of the monetary aspects, to have people counterfeit or copy your product. But if you get skilled workers into your guild, they know that they will be sanctioned if they violate the right of other members. So the temptation will be lessened somewhat. Also, Chinyere most specifically mentioned something that occurred to me as she was speaking. Those who counterfeit, those who copy, are not just individuals who are hungry. Sometimes criminal syndicates are involved. What this means is that it is in your own interest to get a lawyer to represent you. Don't try and fight all your battles on this front by yourself, because they know that you are just one person. But when you have the law behind you, then they know there is a system behind you. I don't know how many minutes we have left. I can tell you that it's been a great session. I hope that this is recorded and the recording will be online soon. We will have more questions later, I guess, and Chinyere's details are available, or you might want to contact me or any other lawyer that you feel
Yes,
will be able to address issues. I must thank you, Chinyere, for a very exhaustive session. It's been thought-provoking, not just for leather workers, even for those who create processes. I was going to say this session is actually much more interesting for me as a lawyer than as a leather worker.
thank you.
And it's going to make me have much more to say to those who want to venture into this line of trade. It is lucrative. The statistics that Chinyere has brought forward are astounding. There is a lot of money to be made, but you have to protect yourself. Thank you very much for joining us on this panel. We hope you'll be with us next year, and I'm sure there will be a lot more of us treating these questions as time goes by. Chinyere, thank you very much.
Thank you so much, Tade. Thank you. Thank you, everybody, for listening. Thank you.
Thank you, everyone. Yes.
Thank you, everybody.
Thank you.